This is where I'll go.
And then if I say an essay last week, you're coming to help with it.
Yes, or would you rather me stay here?
No. That's too painful.
Okay, we are live now. Again, welcome everyone. Today's training, we are doing NYCHA termination of tenancy proceedings. And for this training today, we have Lucy Newman from the Legal Aid Society. We also have Ayana Heward, who's also from the Legal Aid Society. Thank you so much for doing this training for us. So just remember, questions you can ask on the chat. They will be answered throughout, and the materials will be shared at the end on our website. So now I'm going to give it over to Lucy Newman and Ayana Heward.
Hi, NYCHA. Hi, everyone. My name is Lucy Newman. I'm an attorney at the Legal Aid Society in our public housing unit. And I'm joined with one of my colleagues thus far, and I think several others will join. Ayana, do you want to say hi?
Hi, good afternoon, everyone. I'm Ayana Hayward. I'm a paralegal with the Public Housing Unit.
So in, I think it was April, right, NYCHA, we did the training series, the spring training series for Housing Court Answers. And during that time, specifically in connection with NYCHA issues, and during that time, we covered PACT and remaining family member grievances, background kind of NYCHA, and arrears and getting repairs made. And one of the things that came up was termination of tenancy proceedings. And so in response to that, NYCHA asked us to put together this presentation where we will cover termination cases, not remaining family member cases, because I think we covered that last time, and not other kind of grievances, but those proceedings, the administrative proceedings that tenants of public housing may face, and if they do face, may be terminated and then face eviction in housing court. So we're going to start. I'm going to just do a couple of background, just to refresh our memories about all things public housing, and mostly to distinguish this from Section 8. And then I want to talk about the differences between a termination of tenancy proceeding and an eviction proceeding in housing court. And then I'll run through really the nuts and bolts of termination of tenancy proceedings, including from the very beginning of the start of them, the behavior that might be underlying the charges. We will cover actually before that right to counsel, and then, just discuss what form the decision can make, whether or not you settle, and then briefly touch on appeals. So I like to think, because I'm totally obsessed with all things NYCHA, that NYCHA is everywhere. I believe it is in New York City. Hundreds of thousands of New Yorkers call NYCHA home, and it is home to low income and very low income New Yorkers. And so in our practice, which I'm sure many of you are helping people who are facing eviction or have unstable housing or are looking for housing, it really impacts many people's lives. And we respond to many calls in connection with NYCHA public housing and Section 8. So I really truly believe that it is in all facets of our life. And as you know, it's in all 5 boroughs of New York City. So just very, very briefly, today I just wanted to make everyone clear that we are talking about public housing. Public housing and termination of tenancy proceedings are connected, and that is distinct from what happens on the Section 8 side when a subsidy might be terminated. So I mentioned kind of where public housing comes from. It was created, the concept of it as a federal program was created in the Housing Act of 1937. And the reason I highlight here Section 9 is, again, to distinguish it later from Section 8, which has become part of the conversation more generally as a result of some conversions that NYCHA is doing to Section 8 under its PACT umbrella. Basically, under public housing, HUD issues federal subsidies to local public housing authorities. And in this case, we're going to be talking about the New York City Housing Authority, which is our local public housing authority that owns and manages all of the public housing in New York City. So HUD, the federal agency, they get money out of the federal budget, and they have a program called the Public Housing Program, and they issue funds in the form of this operating subsidy and capital subsidy to NYCHA, the Public Housing Authority, to run its public housing program. And again, in New York City, all public housing is owned and managed by NYCHA. You will probably have heard of a couple of other public housing authorities that we have and deal with in New York City. One is HPD, which is the city's Department of Housing Preservation and Development. Is that the right word for it? And then the State Housing and Community Renewal. HPD and DHCR have Section 8 programs in New York City, but not public housing. So when we talk about public housing, we are talking about NYCHA. Just wanted to talk, and this goes back to NYCHA being everywhere. You'll see there photos of, some ubiquitous images of what public housing looks like in New York City. Most of the time, those are the buildings that we see. As you know, there are different types of public housing buildings. Some are much smaller and more what we call scatter site. Just smaller buildings that are on the street front. These images are much more the classic architecture of NYCHA's public housing, which is known as the towers in the park type of architecture, where they are set back from the street front with then parks and parking lots and things like that. We are proud to have the first public housing in the nation in New York City, in First Houses in Manhattan on First and First. As a result of that, many of the buildings are very old. Our public housing stock is aging. You'll see here, 191 out of the 251 developments are 50 years or older. With that comes obviously deterioration of the buildings and other needs that are coming up as a result of the age of these buildings. There is a large number of units in NYCHA's public housing portfolio. It used to be about 20-something more than that, but they've now converted those to Section 8 under the PACT program. But currently there's 156,000 public housing apartments in NYCHA's public housing portfolio. This represents 7% of the city's rental units, hence why we see so many people who are coming to us with questions about NYCHA. The authorized number of residents is about 312,000, but we truly believe that there's more like 400 or 500,000 people that are living in NYCHA. As I mentioned earlier, it is home to low-income individuals and households. The average monthly rent is $588. And what we are seeing right now is an aging population in NYCHA. Many seniors are now the heads of household, and that comes again with its own challenges for how to manage with seniors who are aging in place. I just screenshotted here some pages from NYCHA's fact sheet. Their website has some really great information about what NYCHA manages, both within its public housing program and the Section 8 program. There's also some really interesting parts on their website, including the artwork that is throughout NYCHA's public housing developments, the history of the names behind each development. There's also really specific information around demographics and number of units and all that kind of stuff that you can find on the website. But this is the fact sheet that they usually update every year or so. And you'll see here it gives lots of information about the number of developments in each borough, and the number of households and the ages and things like that. So if you ever have a chance and are interested, that's a great place to find some more facts about NYCHA. So I just wanted to go back to what we're talking about today, which is public housing. And that is really important just off the get-go to understand that we're not talking about those public housing units that have now converted to Section 8 under NYCHA's PACT program. NYCHA's website has a really great part of it, which shows you which NYCHA public housing developments have converted already to PACT and those that are in the process of converting. And if you ever get a call on a helpline that you're managing, or someone who walks into an office that you have services that you're running, and they say that they live in NYCHA, you might want to ask for their address, which you can then distinguish, like find out whether that is public housing. And if they say that they think they're undergoing PACT, you can go here and see live information about whether or not it actually has converted or what the timeline is for conversion. To date, 21,000 units have been converted to PACT, with NYCHA committed to convert a total of 62,000 by 2028, which they look like they are on target to reach. So today we're talking about public housing and the termination proceedings that go along with that, not with PACT converted properties and Section 8. So again, just by way of background, because sometimes this will come up in some of the cases that you might see on termination, is NYCHA residents have income-based rents capped at 30% of your adjusted gross income. They also have a public housing lease, and really that's an important part of the program, because the key thing about the public housing lease is that it is for a period of 12 months, but automatically renewed. And can only be terminated for good cause, which means that at the end of those 12 months, they can't simply bring a holdover against you in housing court and say that they don't wish to renew the lease. There has to be a reason why they don't renew. And that's what we're going to be talking about when we talk about termination of that lease, termination of tenancy. Another key thing about NYCHA public housing is that NYCHA is both the landlord, both the owner of the property, and the deed holder and the landlord, but also the property manager. So you probably know, if you've ever dealt with someone living in NYCHA, that typically on site is a management office, and that is staffed by employees of NYCHA, including the maintenance staff and other grounds people. In the conversions to PACT, Section 8, the property management switches from being NYCHA employees to private employees hired by the PACT partner. And so when we're talking about, we'll get to it when we're talking about like investigating cases and putting on evidence and who does that, we'll be referring to NYCHA's property manager or property management staff, and that's who we're talking about. Every year, a public housing tenant and household has to recertify. They have to give information to NYCHA about who lives in the household and what their income is. And that's an obligation that they have. They also have the right to file what's called an interim recertification. So if there are changes throughout the year that may impact either who's in the household or the income in the household, you can file an interim recertification. And that's important, especially if there is changes in income which might impact rent, which could also have a trickle-down effect about whether or not rent is affordable. And for us in termination of tenancy cases, that can obviously lead to a chronic rent delinquency case. So just know about these annual recerts. Most of the things for NYCHA as a public housing resident today are being urged to be filed online through their self-service portal or the My NYCHA app. In my experience, a lot of the time that doesn't work that smoothly. So if you do hear of a tenant who's calling you saying that they've tried to do that and experienced some difficulty, that's what they might be referring to. I mentioned HUD just in the background here because in public housing, we don't really think about HUD as being very present. I think it's fair to say that a public housing tenant really looks at NYCHA as being their landlord and probably doesn't think much about the fact that their rent is subsidized, because when they get a rent statement, it simply says what their rent is. As when you're a Section 8 tenant, you'll often see what your portion of the contract rent is. But for a NYCHA resident, I think it's fair to say that you kind of live not really having to think about the fact that this is a federally subsidized program. Obviously, with the Trump administration and threats to that funding, this is going to be an issue that we see more and more, and we will update everyone as and when things happen on that. Work order and repairs, which were covered in prior trainings, all of those, because NYCHA is the landlord and the property manager, are handled by NYCHA, and a resident has to call NYCHA to or file a work order request with NYCHA, and NYCHA is the party that has to do those repairs. And again, that might come up in cases involving chronic rent delinquency and other issues that might arise, anytime you're speaking with a NYCHA resident. So one of the questions that we get a lot is mostly a result of confusion, understandable confusion around whether or not someone is in a termination of tenancy case. Is that happening at NYCHA? Did it already happen? And what is the difference between facing a termination of tenancy at NYCHA and defending an eviction proceeding where NYCHA is suing you in housing court? And again, it's really understandable why there's this confusion, and we can cover that in a little bit. I also wanted to say, just by way of background, obviously during COVID, there was the huge pause in any of these cases, including NYCHA's termination of tenancy cases. And at that time, they kind of did a review of the priorities that they had. Any of you who were practicing in this field prior to the pandemic probably remember just how many cases people were being brought up before NYCHA on chronic rent delinquency at 803 Atlantic, which used to be 250 Broadway. And they reassessed, you know, what they were using these termination of tenancy proceedings for. And back in 2021 and 2022, NYCHA said that they were not going to proceed with cases that were solely on the grounds of chronic rent delinquency, CRD cases. But recently they have announced and have started bringing cases that are solely on the grounds of chronic rent delinquency. So we are seeing an increase in the number of termination of tenancy proceedings at NYCHA. And I think as a result of that, you will see more and more people coming to you with a termination case on CRD grounds. And we will talk a little bit about how that's distinct from non-payment. So I mentioned earlier that public housing residents have a public housing lease, and that is a federal requirement, and it's a federally issue. It's the form of it is federally issued, and one of the key parts of that is the fact that it is an automatically renewable lease unless terminated for good cause. So in NYCHA public housing, if NYCHA wants to sue for non-payment and non-payment only, they can go to housing court just like any other landlord. But if they are alleging any other behavior that they believe warrants the termination of your lease, this is if you're a tenant, then they have to go through this administrative process first. And I can talk a little bit about the background to that. This is different than if you are what's known as a licensee. So say you're living in a NYCHA apartment, but the tenant of record, the leaseholder, has either moved out or died, and you are either not on the household composition, or you are, but the lease isn't in your name. You could be taken to court in a holdover proceeding. But if you are a tenant and they are trying to terminate your lease, they have to start at this administrative level. And there is a hearing office, the IHO, the Impartial Hearing Office, which sits at NYCHA at 803 Atlantic, and is within NYCHA, but kind of is this semi-independent office within NYCHA, staffed with people who are civil servants and not technically employees of NYCHA's law department or NYCHA. But again, the Office of Impartial Hearings is actually within NYCHA's offices, and in the same building that NYCHA's law department is at. So these administrative hearings take place from beginning to end at NYCHA's IHO, the Impartial Hearing Office. So the reason why we have this distinction between where you go to deal with a termination of lease issue results from a case that was brought decades ago called Escalera, and that was a case brought about due process violations or lack of due process in the way that leases were being terminated by NYCHA. And the result of that is this consent decree called Escalera. And in Escalera, the judge says the parties have to go and put together some procedures that will ensure due process. And as a result of that, we have this document called the Termination of Tenancy Procedures, which I urge you all to take a look at. And if you ever do end up representing someone in a termination of tenancy case, you certainly should have a copy of that with on you at all times. I just wanted to go back to the issue around where you go to be terminated. As you probably know, in housing court, if you're in a privately owned apartment, then the landlord can seek to terminate your lease, and by notice of termination or notice to quit or a notice to cure. And then if you don't do that and they allege that you didn't do that, they can then bring you to court in a holdover. And that's where you would litigate the issues that they're alleging. So if you do end up with a termination proceeding that goes to a hearing before NYCHA's IHO, the Impartial Hearing Office, then NYCHA can, with that decision in hand, if it says you've been terminated, then NYCHA will go to housing court to get an order in housing court for a judgment, and from there a warrant and an eviction from a marshal. But they need that if there is a tenant in place, they need that before they can go to housing court, which is this decision from the IHO. If you do get brought to court in a holdover proceeding, so if you see someone that says, oh, I got terminated at this termination of tenancy proceeding, and now they've got a holdover case being brought against them because NYCHA now has in hand this order that says you've been terminated. The housing court judge is not going to be looking at anything other than that decision's final sentence that says terminated. They won't look at the conduct that was alleged to form the basis of that decision. They won't look at what happened in that hearing. They won't relitigate or hear any more about, what someone's defenses were. They will simply have attached to that petition something that says terminated by decision of the hearing officer. And they will only be looking at whether or not that holdover was brought correctly, like were the parties served properly, were the right predicate notices served. So the big limitation about these termination cases, one of them, is that the only way to appeal them is in an Article 78, which we can talk a little bit about later. I say confusion surrounds a lot of this. Mainly in my experience, what I see is that if a tenant is being sued in a non-payment of rent case in housing court, but at the same time now receives a notice from NYCHA saying, we are commencing a termination of tenancy case against you for chronic rent delinquency, it's very, very normal and understandable about why a tenant is confused. Why are they being sued in two different places? Are these the same cases? Are they dealing with the same issue? And they may or they may not be. My understanding, and Ayana, correct me, or Jess if I'm wrong, but my understanding was that NYCHA was not supposed to be bringing these cases simultaneously, that they were supposed to be deciding, are they bringing a non-payment or a CRD? That was, is that still true? They're nodding, yeah. So if someone is calling you and they say, I've received court papers for housing court, but I'm really confused because I'm already in a CRD case, they really do need to make sure they deal with the housing court case, because what we don't want is a default in the housing court case that could lead to an eviction, in the same way that if they go to housing court, they really shouldn't think that that now takes away the case about chronic rent delinquency and they risk getting a default in the administrative case either. So unfortunately, it could be that these two cases are happening at the same time. But that's really, I'd say that is the most common situation that we see. And then the other is, I have made an application for it to be a remaining family member, but now NYCHA has started a licensee holdover against me. What do I do about it? And so same thing, they will be getting court papers to appear in housing court, but yet they're getting scheduled for a grievance hearing at the 803 Atlantic, and that also can lead to confusion. But both, I would just urge, as a matter of caution, just attend both so that you can work out what stage each of those is at so that you don't end up defaulting. So I mentioned that, okay, so yeah, so Jess added these to my slides. I just wanted you to see this. So when I mentioned Escalera, which was the case that formed the basis of the termination of tenancy procedures, this is a copy, a photocopy of the decision that was issued, and you'll see here it was in 1971. And so that is a copy of the decision that says, it was brought in 1967, that basically said you need to get your act together, NYCHA, and come up with some procedures that ensure that tenants have basic due process rights when these cases are being brought. And on the right-hand side, you'll see here the document that NYCHA has, which is the termination of tenancy procedures. It's 5 pages long. It spells out the grounds in which you can be terminated, what rights you have at the hearing, what the decision of the hearing officer can be, and other information about those, the whole kind of termination of tenancy process. Again, I really do urge you to take a look at it. If you do have a case, either because you're a GAL, a guardian ad litem, and you're representing someone, or you yourself are going as a representative or as an attorney, make sure you have a copy of them, read through them. There's some really good stuff in here, which we're going to cover in a little bit. But these are the documents, the basic documents. And again, we'll talk a little bit about the management manual and how that spells them out more fully. but this is where it all kind of originated. Ayana, did people have any questions that I should address, or you'll let me know, right?
Yes, I was able to answer it, but while we're here, I do want to just bring this up
Yeah.
to everyone. A tenant asks, can a tenant ignore going to a IHO procedure? And I did answer stating that no, at no point should a tenant avoid going to a IHO proceeding.
Yeah.
They can be terminated. It can be decided to terminate the tenancy on a default. So if a tenant ignores it and failed to show up, their tenancy will be terminated. And the next step will be a holdover. And you mentioned that the holdover is not to fight the termination. They are not decided on the merit in which your tenancy was terminated. They're simply there, just the next step. If you lose the hearing, the next step is a holder just to evict you.
Yeah.
So if a tenant should never avoid going to administrative proceeding.
Yes, so that's a great point, because defaults, and we're going to talk a little bit about right to counsel in termination of tenancy cases, but hopefully we will see fewer defaults as a result of people not showing up. But that was definitely something prior to right to counsel that we would see, I'd say, quite frequently. The problem, main problem with a default is that there's going to be a decision from the hearing officer that's based solely on NYCHA putting in before the judge to say they got notice, we issued the following notices, they didn't show up, therefore can you just issue an order terminating them for on default. And the tenant at that point then hasn't had an opportunity to put forward their case, and the decision will lead to a holdover proceeding, and if it's not challenged within 4 months, could end up being a final decision. You can apply to vacate a default. You have to be able to show good cause for why you defaulted. And then the other really kind of tricky hurdle is that you also have to show a defense to the underlying charges. And so it really kind of puts you on the back foot if you have defaulted. So I would always urge people to go to 803 Atlantic to show up for any appointment that they have around a termination of tenancy case. If they can't get there physically, they should try and call the Office of Impartial Hearings. Jessica has put in that information later in the slides that we'll look at. But really, if you do see someone that calls you and says, I've ended up with this thing being mailed to me and it says I defaulted, I would urge them, first of all, find out what the date was of that default decision, and also what the date of the missed appointments were for the hearing. But I would urge them to go straight away to try and vacate that default. And again, you've got to make sure you write down those two things, which is why you missed it and then what your defenses are. Someone's question is, can a termination tenancy decision be overturned? Yeah, we're going to talk a little bit about how you appeal a termination of tenancy case. It is pretty limited because it's by an Article 78 proceeding, which itself is a limited proceeding. But we can talk about that. Yeah.
Sorry. You said you can vacate. So like in court, the process to vacate is filing an order show cause. Is there a specific form? If you could talk about like the specific process.
Yeah,
to
sure.
vacate.
About vacating a default.
Right.
Yes, there is. I don't know if it's available online, but there is a NYCHA form that is a application to vacate a default. It doesn't need to be on that form. All it needs to be in is in some form of writing that you can submit to them. And again, it says, I am tenant X living at X address. I learned that there's a default issued. I wasn't able to show up because I didn't get notice, or I was sick, or I was away, or my kid was sick, I couldn't miss work, and I have the following defense to the underlying proceeding. But they do have a form of it, and it doesn't need to be anything fancy. It doesn't need to be written by an attorney or anything like that. I'd say the most important thing is run to get there to file it. Because then if they deny that application to vacate the default, you can also appeal that. So you have another bite at the apple, but you do actually have to make sure you put in the information that they need to make a decision on that. Otherwise, they could deny it, and then you don't really have a great grounds to appeal it if you haven't put in good facts in that application.
And then when you submit it, like, do you go submit to your management? Like most people, get the forms from their management, or is it another office?
No, you with the vacate, when you're trying to vacate a default, you really do need to submit it to the Office of Impartial Hearing, because it's the hearing officer that's going to review that application and make a decision on that application. And so even if you are being told it's enough to send it to your property manager, it's not, because at that point it's actually not the decision of the housing authority. The housing authority might decide not to oppose your application to vacate that default, which is often what we'll see. But they are not the decision maker here. It's the hearing officer that is. So it's important that you go straight to the hearing office to do that.
Yeah. And then I would say for anyone, just like with anything with do NYCHA, make a copy of whatever you send them. Like if you write it on handwritten, make a copy of it. Take a
Yeah.
picture on your phone.
Yes, totally agree with that. And if you're mailing it, if you can try and mail it with return certified mail, just so you can get a copy of that, or take it by hand and get it stamped, something like that. Okay, I do want to cover three instances where cases go directly to housing court. These are again a result of the Escalera decision, where they say for anything other than these three things, cases will go to an administrative termination process. So in these following three instances, cases will go directly to housing court. They won't go to 803 Atlantic. They won't go through the termination of tenancy procedure. If it is a non-payment of rent case, so if it's your just absolute plain non-payment of rent case that we see every day, NYCHA versus blah, you haven't paid rent for the following 6 months, blah. So that is brought in housing court. You can raise your normal defenses to that, service, inadequate service, repairs, rent abatement, anything like that, you can raise to that. If I mentioned this a little bit beforehand, if NYCHA becomes aware of the fact that the tenant of record or head of household, and when I refer to those two, what I mean is the leaseholder, if they learn of the fact that the tenant of record has moved out permanently, so say the tenant of record submits a form to NYCHA that says, I'm giving you notice that I'm going to vacate, pursuant to my lease, I have to give you this notice 30 days in advance. I am leaving. And so if they move out permanently, or if they die and NYCHA becomes aware of that, and they learn that there are some people in the household who are still staying there, but they haven't come forward to try and succeed to the lease, or they're not making a claim to succeed to the lease, or they are not an authorized household member, then NYCHA will likely bring a holdover proceeding on the grounds that those people are licensees and that they're staying in the apartment without permission of the tenant, because the tenant has either moved out or died. So I would say sometimes NYCHA waits a long time to do this. Like we've had some cases where a tenant of record could have been dead for 2 years, 3 years, and NYCHA still hasn't commenced a holdover proceeding. And that's not because, for example, the remaining person is in the middle of a remaining family member grievance. They simply just haven't got around to it. And then we'll see other cases where within 3 weeks of someone dying, they're commencing a holdover proceeding. So I think it really depends, much like many things in public housing, on what the property manager is like, whether they're on top of stuff in terms of like how well run their property is, and whether they are acting, promptly on all these kind of issues. It also depends on what the relationship was like between the former tenant of record and or any of those household members. So if they were already known to the housing manager, then maybe that will be brought more quickly. If they were problematic, or if they know that there was a whole host of people who are not authorized, they might move more quickly. But I think it's really hard to say that, it's one, they always bring these cases pretty quickly. But those are when you will see a licensee holdover. The other cases, and again, this is a result of Escalera, NYCHA came back to court and then they updated parts of Escalera in 1996 to say that where NYCHA is alleging illegal drug activity in the unit, then they can bring a case known as a Bawdy House case in housing court directly. They don't need to go through the process of terminating first in an administrative proceeding. I don't think we see that many of those cases, but I have not been doing housing court practice for a while now. I know they definitely do bring them, but I just don't know how many of them they bring. But in those 3 instances, that is when they can bring a case against non-payment and the drug holdovers or against the tenant of record. And for the licensee holdover, that's when they would bring the household or anyone in the household to housing court directly without having to go through the administrative process first.
So just want to ask a question. One
Yeah.
question we frequently get is that the tenant of record either moves out or unfortunately passes away. And even if someone is not on the lease, can they still apply for the RFM in the meantime?
Yes. And Jess and Ayana, feel free to jump in if you want. But yes, so if the tenant of record dies or moves out, then and the person wants to try and succeed to the tenancy, they can go in and say, I'm filing a remaining family member grievance. Anyone can do that. But what's going to happen is if they are not an authorized household member, what's going to happen is the property manager will get their remaining family member grievance request and will look at who's on the household composition and say, well, you weren't an authorized household member, I'm denying it. And that's like the first denial. And then they can then appeal that again. But if they don't really have any merit to their case, like they can't show anything that might give them a reason to think that they were formerly there and then removed improperly or tried to get added, but nothing happened, for many years, it's just going to get denied. And then it's possible that the housing court judge won't keep adjourning the case for that to be decided. Obviously, they could file an appeal again in an Article 78, but if you don't really have, underlying grounds for being able to succeed to that lease, it's probably not going to be granted. But yes, anyone can make that RFM claim. It's just whether or not it's actually going to get granted. And in most cases, you have to be an authorized household member and then all of the other parts of what makes a remaining family member. So keeping up to date with UNO, passing the criminal background check, being on the household composition for 12 months with permission prior to the vacatur of the tenant of record, things like that. But yes, you can make that application, but it will likely be denied. Ayana and Jess, is that your experience as well? Yeah, they're nodding. And those are pretty much most of the cases that we would see I would say in housing court, if they are not a non-payment of rent case, most of the cases are people who are being brought to court on a licensee holdover and then trying to make the claim to be to succeed to the lease. We do obviously see some holdovers where NYCHA has obtained a termination of tenancy decision in a hearing and the tenant is still there and then is being sued in a holdover. But I'd say most of the cases are licensee holdovers where the tenant of record has died or moved out. Okay, so now we're going to talk about the actual proceedings and some of the policies and procedures governing them. And I think for me, the thing that I really want anyone to take away from this is NYCHA has obligations that are spelled out in that Escalera consent decree, the termination of tenancy procedures, their management manual, federal law regarding due process, and they have to follow and comply with those obligations. And you should make sure that you raise that and bring that to the attention of any hearing officer at any stage that you're before a hearing officer and in a memo of law if you're then submitting one at any time, because if they fail to comply with their procedures, the appellate judges in Article 78 have been very clear that if they don't comply with their lawful procedures, then they will undo whatever decision happened at the termination of tenancy, and they'll have to start again. And so this is really your one hook to be able to, first of all, hopefully get NYCHA to drop several of the charges if they brought multiple charges against you, but also to protect the record if you do then need to appeal it later. This is a little slide that I've had for years, but I just was hoping to convey the kind of different entities that are at play in any one of these cases, because of what NYCHA is like and the way that it manages all of these units, and again is both the landlord and the property manager, it really does change the dynamics a lot. So for example, you could be living in a privately owned apartment and the LLC that owns the building doesn't know even who they've rented to, right? It's that they then have a property management team who's either one that they contract with to do that or is their own in-house, but is not the same as the LLC, but they're very distinct entities. And at NYCHA, because of the fact that you have this property management on site, it kind of changes the dynamics a lot. And because of your obligations to let them know of who's in the household and the policing, the historic policing that's gone on at NYCHA and things like that, there's just a real like dynamic that is going on here. So you'll see here, I've put Marcy houses. What I'm trying to convey here is that you've got the management office on site, and then you've got a bunch of different buildings that make up the development that's known as Marcy houses. And that's kind of where your regular NYCHA tenant, that's their existence. If everything's going fine, they come home after work, they live in their apartments. Sometimes they go down to the management office because they need to get repairs made. Hopefully they're treated with respect, and you know, the management office is responsive to their needs. They also can go there to recertify their rent, or mostly they do that online now, but that's where you would go historically to pay your rent, to you know, deal with your property manager. Again, a lot of that function has been kind of urged to be moved online, but that's kind of your existence on a day-to-day basis. And some residents, and Ayana, you and Jess, you're very familiar with this because you handle so many of these cases, but in my experience, you will have a tenant who has a very good relationship with the property manager, either because they just don't even know who the property manager is because they're just not a problem. They don't have a problem with each other. They don't really need anything. They are literally just living there. They come and go. They pay their rent. They have no issues. But then you might have someone who does need the help of the property manager, and maybe the property manager doesn't like that person and just does everything. There's a bad situation going on between the property management and all the maintenance staff, and they've just decided they have beefs with each other, and there's nothing you can really do about that. But that might inform a lot of the basis for what then happens with charges being brought against them and how it might be not resolved and things like that. And so you can have some people who have never even heard of 803 Atlantic, have never had to go to the management office. And then you might have some people for whom this is something that comes up quite often in their families' lives, or it just because there's a problematic property manager and things like that. And then you have 803 Atlantic, which is back in the day used to be 250 Broadway, but now we are far enough down the road from it not being that I haven't put that anymore. But that's where you have this OIH, the Office of Impartial Hearings, which will hear any of the cases to decide whether or not you're terminated. We'll also hear the grievances and things like that. NYCHA's law department sits at 803 Atlantic, and that's also where the FOIL unit sits as well. It could be at NYCHA, so I don't know currently whether that is correct. So you should check that. But these are, for every day, a tenant is never going to even know of the existence of 803 Atlantic. It's only when we start talking about these proceedings that 803 Atlantic becomes known in their life. Here is a little rundown of start to finish what a termination of tenancy proceeding can look like. I wanted to talk a little bit about right to counsel, but on the left-hand side, you'll see chronology, which is NYCHA is alleging conduct or lack of conduct by a tenant and or their household members or their guests. So that could be behavior that they think is problematic. It could be that they've failed to recertify. It could be that they are alleged to have misrepresented their income, committed fraud. It could be that they haven't complied with the community service requirement. So this is where the landlord, NYCHA, is saying, you're violating your lease, because you said in your lease that you're going to abide by the following rules and that you're not going to do the following things, and you have, and therefore we're going to bring you up on these charges. And so the property manager, who has a much better, in quotes, understanding of what's going on the ground, might say, hey, the person in 2F has been smoking in violation of NYCHA's smoking policy. Actually, I'm not going to use smoking because that has its own enforcement. They have 6 dogs, and NYCHA's pet policy only allows 1 and or a service dog, and they've got 6 and they're not registered and they're not allowed them. They are violating the lease and the pet policy. We have to bring them up because I don't like that, and that's a violation. And then the law department should do their own kind of investigation and say, you're right, you've given us enough information to suggest that they've got these 6 dogs. We're going to bring this termination of tenancy case. And at that point, the law department will write up specification of charges saying you, 2F, are violating the pet policy in the following way. We're scheduling you. We're going to move forward with terminating you. And I'm going to talk a little bit later about some of the notices they have to send before that. But Ayana and Jess, can you quickly just explain the RTC process? Because I think that has really now changed probably what people are seeing, the types of calls that might be coming through, because in my experience now, most people should be getting right to counsel and therefore not actually having to go for the first time ever to talk to someone once they've been terminated or had this case. But we do know that many people are not showing up for right to counsel. So therefore, are they then not getting attorneys and finding themselves unrepresented at these hearings? So do you want to talk a little bit about the notice and what the RTC process looks like?
Yeah, sure. So the idea of the Right to Counsel conference is to provide representation for NYCHA residents who are facing termination of their tenancy. And there is a letter that Lucy has here. This is what the tenant should receive, and it will have a scheduled conference date for Right to Counsel. The Right to Counsel is, at this time, it's done via Teams or Zoom, I believe Teams. We staff legal services, we staff these conferences. So you'll have a representative from the Office of Impartial Hearings. You'll have the NYCHA attorney. You have a legal service provider, and then the tenant is expected to show and appear in these conferences. At these conferences, the tenant is asked if they would like if they would like to meet with legal service providers to obtain legal services for their cases. If they agree, the Office of Impartial Hearings representative, the NYCHA attorney, they will exit the call, and the legal service provider and the tenant will remain on the call. The legal service provider will screen the tenant for eligibility. We often get the charges from NYCHA. We'll go over the charges with the tenant. We'll get their side of the story. And if they are eligible, we refer them out to our borough offices for representation. But many of the time, we paralegals here, we take our own cases and we represent the tenants in the administrative proceeding.
And I think each legal services provider obviously has their own internal procedures about who's handling those cases. But what should be happening is when they commence a termination of tenancy case, the tenant should get this notice that says, we are commencing a formal proceeding to terminate your tenancy. You're going to get given an opportunity to be represented by counsel pursuant to New York City's right to counsel law. You have to show up on this date at this time. And that's when they will meet with the legal services provider. And again, like Ayana said, either then the legal services provider will take their case or advise it out. But most people should be getting this and on the first date appearing. If you see someone that says they don't even know what you're talking about, they never received a right to counsel notice, and that now that what they're getting is now the next notice that says they've got to go to 803, that's probably what happened, is they either didn't get the notice or didn't show up. You should urge them to reach out to a legal services provider or go to 803 and explain that. And then I think that 803 gives them the listings, right, Ayana, of the different providers. But if you do hear someone that says, hey, I've suddenly found myself in this situation where I've got this termination of tenancy case, I don't understand what happened, you should make sure that they get the list of providers and reach out to one of them to say that I didn't get my opportunity to see if I wanted representation.
I was just gonna add that a recent change over the past few months has been that it used to be that as a courtesy, the hearing officer would also call the tenants if they didn't receive, if for some reason they didn't receive the notice or they're not showing up. And so we would be able to connect with tenants who maybe never got the notice through that, and now they're no longer providing that courtesy. And so that means that if someone doesn't show up, then we're not reaching out to them directly either. And so we're seeing a drop kind of in the amount of people that are showing up simply because that courtesy is no longer being provided. Yeah, so that might be also something that you're seeing, that more people are not getting connected with representation. That change.
The other thing is that currently these right to counsel conferences are scheduled, as you see, like for a specific time. There's like a half an hour window, I think, where you can appear for it. Most people in our experience join by telephone, not on the Teams invite that is attached to that notice. We are working with NYCHA to make changes to this notice so that it's more simple. There's a lot of information in there, and as you can see, it's only at the bottom of that notice that it actually explains what time you're supposed to be appearing somewhere. So we're making edits to that to put that right up front so that people have a better understanding of what they're supposed to be doing, because this is, as you can see, a lot of language to try and understand what is happening here. I just missed that question, Jess. Did you see what it was? Someone put a question in the chat.
Yeah, it's asking about representation for eviction cases as well. I'm
Yeah.
assuming for
Yeah.
like housing court or landlord tenant court.
So that would be just the regular right to counsel program in housing court.
Yeah, and a difference I feel like is that with NYCHA RTC, most legal service providers do have capacity to take all the cases that come in that are eligible, versus in housing court, there's a lot less capacity.
Yeah. And part of the reason why it was so important to expand right to counsel for these termination of tenancy proceedings is kind of, well, multi-fold, but obviously the sheer number of people that live in NYCHA housing, therefore like the numbers of potential termination tenancy cases, but also if you don't litigate and or put in the record at this stage and defend these cases at this stage, the administrative stage, the only appeal you have is later in the Article 78. And the Article 78 is a very limited type of appeal. And so it used to be that when we would see someone coming into our office with a termination of tenancy decision, unfortunately, there was very little we could do because there wasn't enough in the record to be able to make a meaningful appeal. And so we're really hoping that by having representation up front, with attorneys or reps up front, we can either get rid of some of the charges, settle them, or at least put enough in the record to help, preserve the record and be successful on appeals. So the right to counsel at administrative proceedings is really, really important. Unfortunately, the right to counsel does not extend to remaining family member grievance cases. So it's only for termination of tenancy cases at NYCHA. So if you do see someone who comes into you with this letter talking about a right to counsel, that's what that is about. This is just a list. We can do that later, but this is just spelling out, and we'll cover what it means for a GAL under Blatch to be appointed. And then if you do go to a hearing, what that looks like, and then what happens with the hearing officer's decision. I'm going to take you back to Escalera. In Escalera, there is language in the termination of tenancy procedures, that 5-page document that you're all going to be walking around with in your bag, that says these are the grounds as spelled out and agreed to back in 1971 that NYCHA can bring termination of tenancy cases for. As you see, it says these procedures will deal with termination of tenancy brought on any of the following grounds: non-desirability, breach of rules and regs, chronic breach of rules and regs, CRD, chronic delinquency in the payment of rent, NVI, non-verifiable income, assignment or transfer of possession, and misrepresentation. And so when you do then get brought up on these termination of tenancy cases, it has to fit into one of these grounds. And I'd say that most common would be CRD in D, which is chronic delinquency in the payment of rent. NYCHA uses this, and we can talk about it in a sec about they're really using this as a way to collect rent, not necessarily change behavior or obtain a change in behavior. And then we would see non-desirability, which is where they are alleging that either the tenant or someone in the household or a guest has engaged in behavior that they think does the following things: is a danger to the health and safety, a danger to NYCHA's employees, and things like that. We definitely see NVI, which is not non-verifiable income, which is where people are alleged to have not done their affidavits of income. Usually you can resolve those with filing your affidavits of income. Misrepresentation is also one that we see, where they're saying that you haven't been forthcoming or truthful about the income in your household. And assignment or transfer of possession, a lot of those cases that end up in a decision is cases where the tenant of record has been moved to a rehab facility and is not going to be returning. There is no plan for them to return to the apartment. And we recently did a FOIL request and got copies of all of the decisions issued by NYCHA in these cases. And there are a lot of those cases where the tenant is not going to be returning, is not in the apartment, and has not been in the apartment for quite a while, and therefore they're not occupying it, and they can be terminated on that grounds. But you will find the grounds in the termination of tenancy procedures and also in the management manual in Chapter 4 of NYCHA's management manual that spells out all of the grounds and all of the procedures that we're going to talk about. Chronic breach of rules and regs and breach of rules and regs is in the lease. You'll see that the tenant agrees to do certain things and not to do other things. And so, for example, not keep pets unless they're registered, not wash their windows from the outside, only from the inside, not have barbecues if there is a balcony on the balcony. You know, that kind of thing would form the basis of breach of rules and regs. And you are given an opportunity to cure that. So if before any decision is issued or hearing is issued, you can show that you've done something to fix that, then maybe you can avoid being terminated on that. The other one I do want to talk about a little bit is violation of permanent exclusion, and we're going to cover permanent exclusion up ahead, which is that one of the ways that residents can preserve, one of the ways that a tenant can preserve their tenancy is if they have been brought up on a charge of non-desirability for behavior other than their own behavior. Then they can settle and hope to save their tenancy by agreeing to exclude what they call offending individuals. So say you're the tenant of record and they say that Jessica, my friend, who's been staying with me, went out and committed some offense, criminal offense, and that therefore she's a danger and a threat to something, then I might agree, in order to save my own tenancy, I might agree to excluding her from the property, which means not only excluding her from coming to my apartment, but also to coming to the development. And it used to be a permanent exclusion. And a number of years ago, a group of legal advocates came up with some changes to that policy, which now allows you to apply to have the permanent exclusion lifted, or it will just be lifted automatically by passage of time. And we'll talk a little bit about that. But you can be brought up on a violation of that permanent exclusion if they find the offending person to be back on the property or in your household. And that is not an uncommon charge that we might see. I just wanted to give you just a little bit of examples of some cases and what you might really see in reality, rather than just on the paperwork that we're going to be reviewing. I once had a case with a really, really lovely senior who lived down here on the Lower East Side. She was 92. She had received specification of charges alleging that she had threatened a neighbor by spitting in his face and using threatening language. My client was about 4'9" and 92 years old, and walked with a cart to to hold on to when she was walking. And the person that she was alleged to have been, threatening was a man in his late 30s who lived 2 floors above her. And the thing that brought this case to NYCHA's attention is that she had actually been arrested and charged with criminal menacing for this behavior. And NYPD shares information with NYCHA about arrests that are made on NYCHA property, or cases where someone who has been arrested gives a NYCHA address as their home address. And so that's how a lot of the time NYCHA becomes aware of a case involving an arrest. Sometimes they might become aware of behavior because there's execution of a warrant at an apartment, and therefore they learn about that. But it's very important to note that unlike in private housing, NYPD is sharing this information and sending that information on a daily basis to NYCHA. As part of their policing of NYCHA. So this 92-year-old woman gets these termination of tenancy charges, and we were actually headed towards a hearing on that case. The DA's office sent through videos of the alleged behavior. NYCHA was unwilling to settle the case, notwithstanding her 60+ year tenancy. Unfortunately for my client, she ended up passing away before they resolved that case. The other case that I thought was interesting was I had a client who had a kidney transplant when she was and her 2 sons, who one of whom lived in New York City but did not live with her, and another son who lived in the South, had come up to take care of her. And when she was in the hospital recovering from her kidney surgery, they got into a fight and one stabbed the other one. And this became known to NYCHA because of the NYPD and the arrest. And then she was home, was trying to get better, and then suddenly was served with a specification of charges for having unauthorized occupants and for non-desirability based on their behavior. And we were able to show that one son lived in down south and that the other one didn't reside with her. But it's those kind of everyday things that happen to people that can form the basis of these termination cases. And I'd say that we get a lot of emails and calls from our colleagues in our criminal defense practice who will have a client who is being charged with a misdemeanor or a felony, and they say to our colleagues, I live in NYCHA, or my grandma lives in NYCHA, or my mum lives in NYCHA, and I'm really worried that this is going to impact their housing. And then we have to advise them on, in some cases, there is a large chance that NYCHA is going to bring a termination of tenancy case against the tenant based on this behavior, either because it occurred on NYCHA property or because they live in a NYCHA apartment. So there's just lots of different ways in which this can come up. Employment income is definitely something that we see a lot of. Ayana right now is defending a case where our client's ex-husband was reporting income to her apartment. She didn't know about it, and therefore she was brought up on fraud charges and actually criminally charged with that because she didn't report that income but didn't actually know that he was doing that. So there are lots of messy situations. Some are easier to deal with than others, but just a variety of behaviors that NYCHA is looking to deal with. But non-desirability is I'd say pretty much the trickiest ones that we see. So I mentioned before the limited appeal that one has from a termination of tenancy decision. And that appeal is known as an Article 78 proceeding. I do not know if HCA has done a training on Article 78s, but I know that you can get them online pretty easily. But an Article 78 proceeding is a summary proceeding, and it is the appeal that can be brought in state Supreme Court in which you would say, I have this decision either that was issued to terminate me based on a default or after a hearing in which they found that they were going to terminate me, and I want to appeal it. And there are limited grounds for appeal. They are things like arbitrary and capricious decision, that the penalty was disproportionate, that it was a violation of NYCHA's procedures, those kind of things. But again, it's limited. And also the judge in that case in State Supreme Court can only look at what was in that decision and what was put before the hearing officer at that decision and raised before that hearing officer. When you read the decisions of the hearing officers, you'll see that they many times are very careful to put in there everything that they think will protect it from kind of being overturned at appeal, making sure that they tick all the boxes. And then in others, you'll see that maybe they don't because it probably wasn't raised at the hearing. But the key point is that they can't look at anything. So you might see someone who comes to you and says, but they didn't know this, they didn't know that. I had this situation, I had that situation. When you look at the decision, you have to just say to them, like, unfortunately, that wasn't evidence before the hearing officer, which means that this judge can't actually look at that. And the case law is really strong on this, that they can't look at anything that wasn't as part of that decision. So it's very important that we put everything and more before the hearing officer so that they have to address that. And if they don't, at least you will have something to say, like they violated procedures by not addressing that. We talked a bit about defaults and how if you seek to vacate the default and that is denied, your appeal is through an Article 78. Procedures are fun. Okay, this is where we get down to a bit of like nitty gritty, but again, this kind of goes back to preserving the record, making sure that everything and more is before the hearing officer, or even before that, before the NYCHA attorney, so that they can also weigh if you're especially trying to get to a settlement, or you're trying to see, you're trying to urge them to settle it, or start rethinking like what charges they're really going to stick with. Then you want to know what the procedures are and what they entail, and you need to raise those along the way so that you can protect your record. So I'm going to go through some of the obligations they have before, during, and after the hearing that they have to comply with. And again, it's mostly about, for our purposes, it's mostly about ensuring that all of this is in the record, but also we can get rid of some of the charges ahead of that by explaining beforehand to the hearing officer that they didn't do these things. So in the termination of tenancy procedures, your lovely 5-page document, you will see here that it talks about the hearing in paragraphs 5 and 6. And it spells out kind of what needs to happen and what some of the rights are to put in certain evidence. So for example, in paragraph 6, it says that the tenant can put in evidence, and then it says that notwithstanding any other things, you can also put in mitigating circumstances. So even if they don't form the basis of the charges, you might want to bring to the attention of the court other things like I will be homeless if I lose this apartment because of the following reasons, or there are the following individuals in my household who are disabled, and you really should think about that before you issue your decision and how that might impact us, or other things that could impact the case. But this is where you'll see some of the rights and the obligations of the parties and what the hearing officer has to listen to and deal with. I want to talk a little bit about Blatch. Blatch is a case that Legal Aid brought in 97, again, to do with due process, in which we were claiming on behalf of Kelvin Blatch and his brother, and it ended up being certified as a class, saying that when it came to tenants who are disabled, but what they define it in this decision as being mentally incompetent. So if someone has a condition which means that they're probably not able to defend themselves, then they were not receiving due process when they were going before these hearing officers. And that case ended up with a decision and an injunction, a permanent injunction, And as a result of that, there are procedures in place about appointing guardians ad litem, GAL, to cases where NYCHA believes that the person is in need of a GAL because of their competency issues, or if there's been a finding that they have competency issues. And so if you do meet someone either as a client or that you're helping in these kind of cases and you think they might be in need of a GAL, then you can turn to this the Blatch settlement and the procedures that spell out when that has to happen and how a GAL gets appointed in a termination case. Blatch doesn't just cover terminations, it covers terminations and it also covers housing court cases, including non-payments and holdovers. In a termination of tenancy case, what the injunction says is that if NYCHA is in possession of information that leads them to believe that someone might need a GAL, then they can't proceed with a termination of tenancy case until they've appointed a GAL. And they can do that themselves, or they can have a social psych evaluation performed, which is done by their own social services team. And then they will go and interview the person and issue a decision about whether or not they think that the person needs a GAL, and they'll appoint one or not appoint one. If you see someone that already has had the hearing, but you think that they might have needed a GAL, they can actually move to vacate that decision on the grounds that they should have had a GAL. But if you ever hear someone talking about Blatch or GALs in termination of tenancy cases, this is what we're talking about. And again, that's a permanent injunction. And so that's for every termination of tenancy case. So the NYCHA has, on its website, you'll see that there is its ACOP, which is a collection of many of its policies and procedures. And some of those policies and procedures are contained in their management manual. Chapter 4 of their management manual specifically covers termination of tenancies. There are other chapters of the management manual that deal with occupancy and applying to NYCHA and then lease signing and then rent calculation and pets and remaining family members. But chapter 4 deals with termination of tenancy. So if you want to get into the policies and procedures, this is where you're going to find them. I would say just familiarize yourself with them if you are going to take on one of these cases. You'll see here that in chapter 4.2a, this is kind of interesting because this is something that you could point out if necessary at a hearing or before the hearing officer and see what NYCHA says about it or what the decision is. But it says here that if NYCHA is going to bring a case where they're alleging behavior by the tenants or the tenants' families, so I'm thinking a non-desirability case or a breach of lease case that involves some type of activity or failure to act, then the manager should attempt through discussions and referrals to social agencies to correct the conditions before they reach a stage where there is no alternative but termination proceedings. So that is an affirmative obligation on NYCHA's part to do that, to go and see if there's anything else that can be done before they resort to bringing a termination of tenancy case. So maybe, especially for like chronic rent delinquency, has NYCHA, and there are specific obligations as it relates to CRD cases, but have they done everything that they could do by getting you budgeting help or working with public assistance or seeing if they can help you get an arrears grant? Have they done all that stuff before they suddenly just serve you with this specification of charges? I'd say that in most instances, no. But at least if you're going to go to a hearing, you should definitely bring this up. And when you're questioning the property manager or any of their witnesses, you should, question them on whether or not they've done anything prior to bringing this case. And if they say no, then I think it's fair game to say that you should want the case dismissed because they haven't complied with their obligations, or you can at least raise it on appeal. Escalera and the termination of tenancy procedures state very clearly that, and this goes to the due process aspect of stuff, which is that before you're terminated in one of these cases, you must be given the opportunity to have a hearing, and you must receive written charges specifically on the charges that they're alleging. And remember, the charges are things like non-desirability, breach of lease, NVI, misrepresentation. They have to write that down and they have to specify what it is that they're alleging, and they must serve you with that written specification of charges. And we'll talk a little bit about how vague sometimes those charges can look. And then again in chapter 4C5, it says before the close of the hearing, the tenant or his or her rep can make a statement in mitigation about why the tenancy shouldn't be terminated. So again, this is where you might raise, like, my grandma lives with me, and if we were to lose this apartment, moving my 90-year-old grandma is going to be really, really hard. Or we're a family of 6, where are we going to go? Things like that, that even though they might not be a direct defense to the charges alleged, the hearing officer might say, yes, NYCHA has proved their case, and it would ordinarily warrant a termination. But in this case, there are mitigating circumstances that suggest that we shouldn't terminate the tenancy. So therefore, I'm going to not terminate the tenancy. And if you try to put in mitigating circumstances and have someone there to testify about it, or you try to put in documents about it and you are denied that opportunity, this is where you would then point again to them violating their procedures. So any of these things, just keep in mind that you should raise at the hearing stage or along the way, and make sure that you're getting decisions on that, so that you can, challenge them later, or even challenge them at that time. Any matter not made available to a tenant or a tenant rep for review upon request prior to the hearing cannot be relied on by the authority at the hearing. So say you've got a case that's non-desirability, and they say that you were urinating in the elevator. We have camera footage of it. And you say, we would like to get a copy of the video from the elevator, and they say, we don't have it. It expired, or it got, deleted. But then they try to bring that in at the hearing. You will say, objection, we made this request and it wasn't made available. You can't rely on it. Or more simple than that, you ask for something and they just say no, and then they whip out the file at the hearing, and then they start moving forward on it. So it's your job to make sure that when you're preparing for these things, you, in working with your client and working out what's going on, you make requests for any information you think might be there, and or that's part of the tenancy file, so that you can again form, challenges to any denials that they might make, or not be forthcoming with information. One of the consent decrees, along with Escalera, is another consent decree in another case called, it was actually 2 cases that were combined, called Randolph-Tyson. And that was based on alleged non-desirable behavior by members of a tenant's household. So not the tenant themselves, but members of the household. And the way that they resolved that case, or one of the ways in which that case was resolved, was if the tenant can show at the time of the hearing, so when it's before the decision maker, if they can show that the offending person is no longer living in the apartment, so maybe they are incarcerated, or maybe they've moved out of state, or they've got their own apartment, but if they are not living in that apartment anymore at the time of the hearing officer cannot terminate the tenancy. They might put the person on probation, meaning the household on probation, or they might say that that person is permanently excluded, but they cannot say that that tenancy will be terminated. And Randolph-Tyson is a really important protection that we have together with permanent exclusion, because it preserves the tenancy for the tenant, and they won't lose their apartment for the rest of the household members because of one offending individual. And that's important because this US Supreme Court has found that a tenancy can be terminated because of behavior of a household member. And so the permanent exclusion and Randolph-Tyson are our way in New York City in public housing of protecting ourselves from that Supreme Court decision. So if you agree to exclude someone, or you can show that they don't live there, you cannot lose the apartment for the rest of the household members. And that's really, really important protection for us. I talked about procedures for commencing, during, and after. These are 2 good ones for when you bring the charges against a household. And you should always ask for copies of these letters. A lot of the time we overlook these 2 kind of documents because we're focused so much on trying to get to the heart of the case itself. But these are important because if they haven't served the tenant with these notices, again, you can raise it either at the hearing and say that they didn't commence it properly, or you can appeal it later if you raised it at the hearing and said they didn't commence it properly and the hearing officer ignores you or says it doesn't matter, then you've got an appeal. One is called the 185 letter and one is the 187A letter. They are what's known as call-in letters. The first one is a letter that says, hey, I'm your housing manager. Something's come to my attention. I want you to come and speak to me on the following date and time. In my experience, many of my clients don't go to that meeting. If they called me at that stage, most of the time I wouldn't see someone at that stage of the proceeding because either it gets resolved at that stage, or if they come to us later, it's too late for us to do anything about that appointment. But if you do see someone who gets that letter, I would just urge caution, which is that anything that they say at that hearing could be put into interview records and notes, and it could be harmful later, could be helpful, but it could be harmful. So just, if someone does reach out to you with the 185 letter, you might want to just counsel them on that. If at that initial call-in, if they do go to the interview or the meeting and the housing manager says, you know what, it's fine. I didn't realize that was the issue. I'm not going to move forward with this case. Then that will be it. But if you either don't show up and the housing manager does want to proceed, or you go to that and then the manager says, no, I don't like this, then you'll get what's called a 187 letter, which is the manager saying, I'm moving forward with this termination of tenancy. I've now sent your information to the law department and you should expect to get specification of charges because we're going to move forward with the termination of tenancy proceeding. When you do finally get your tenancy file or your client's file, or if you're just helping them as a friend, you should definitely request their tenancy file. Ayana and Jess, is it still the case that when you do these cases, they are only presenting you with what's known as the dummy file, meaning the documents that NYCHA thinks is just sufficient for this case, or are they presenting you with the whole file?
I think sometimes it depends on the attorney. Some attorneys will provide you with the entire file. Some attorneys will only provide you with their dummy file, and you will have to set up an appointment with that attorney to view the entire file in person at 803 Atlantic.
Okay. So NYCHA keeps these files. It depends on the length of the tenancy, but sometimes you'll go there and it's really like stepping back in time, because you might have someone that apartment has been their family's home for 30 years, 40 years, and the tenancy file is going to be, this thick, and starts with the first page is the initial move-in household composition, and you'll see all the changes made over time. And it's pretty amazing to see some of these old files and the household members that have come and gone over the course of this lengthy tenancy. But do make sure, especially if it's not just a case that is really kind of, simple and related to one incident or whatever, to get a copy of the tenancy file in full and not just the dummy file. It's really important, because if your client is saying to you, I've never had a problem, I don't even understand what this is about, and then you go there and you realize that the family has had multiple termination cases that have been resolved through probation, or they have failed to recertify on multiple occasions, that will be helpful to you, because at least then you're going to know that before you put someone on, to testify, or even just, you need to understand, is this really what's going on? What is going on? And obviously it's a one-sided note sometimes about what's been going on, but I think it's really important to see that. Additionally, if, for example, it's an RFM claim and someone is saying that they did attempt to be added, you might see that in the interview records, but they're just really important to go through. And also there you'll see whether or not they've put in notification or copies of the 185 and 187 letter. So always, if you can, get a copy of the entire tenancy file. I mentioned that you are entitled to written notice of the charges. The main thing about this is that if you are going, and it looks like you're going ahead with a hearing, you might want to think through whether or not you can get some of the charges dismissed at the hearing stage before the hearing officer even has to listen to those charges. So the tenant is entitled to clearly stated charges with facts and dates. I think it's not uncommon to see cases where they say, we're charging you with non-desirability in that, and then it will say, in 2017, someone known to the authority threatened an employee. In 2019, someone in your household did the following thing. I would say that that is not sufficient. That doesn't accurately give you the facts that you need and your client needs to be able to defend that case. It's too broad. It's too vague. Like, what was the behavior? Exactly when was it? Like, can you show that the person wasn't even there then, or was away on vacation, or was in the hospital, or whatever? So any statement like that, I think you should challenge before the hearing officer and urge them to dismiss the charge as being in violation of this obligation to properly specify the charges. Raise it on the record and make sure that you get a decision from the hearing officer on that. This is a copy of some specification of charges. This is what it will look like. You'll see here that we have chronic delinquency in the payment of rent. The definition for NYCHA's purposes is that you are late paying your rent. Is it 3 months in a 12-month period now? Is that the current standard? I can't remember if it's 3 or 4, but
I think it's 4.
So, you know, unlike other residents living in private apartments who maybe instead of on the 1st, you send in your check on the 5th or the 6th, if you do not pay your rent, unless you're on public assistance and you're getting your rent paid bi-monthly, like you have to pay it in full by the 1st of the month. And the standard is pretty low in terms of when they can bring you up on a CRD case. In housing court, if you're a private tenant, there's no way that a landlord could just say you were late 4 times in a 12-month period. A housing court judge would just chuck that out and say that you didn't, this doesn't rise to the level of CRD. But for NYCHA, CRD is a very common termination case that they bring. And I mentioned earlier that they are now commencing CRDs again as single charge cases. So for the past couple of years, they've only tagged on CRD if it is in addition to another charge, but now they are moving forward with CRD cases. What they're really looking for here is to get the rent paid. And there is an MOU that NYCHA has with HRA that spells out things that are supposed to be going on between those two agencies to get rent paid. And you might want to take a look at that MOU. But you will see that you should definitely ask for a copy of someone's rent ledger. You should see whether your client has tried to pay rent and it's just not being credited. Anything like that. I think many times, so these cases are usually brought or handled by housing assistants at NYCHA and not lawyers. They don't actually get handed over to a lawyer until they've decided that they can't settle the case, and then it will be the lawyer that moves forward with doing the hearing. But before that stage, it's really just dealt with a housing assistant. I think in our prior trainings, we've talked about rental arrears and the CRA program and the Home Art program, but you can always reach out to us if you see someone with a CRD case. And just remember that if you see someone with a CRD case and a non-payment case, they do need to address both of those cases. It's not enough to think, oh, I settled this CRD case, everything's good to go. You've got to make sure, and vice versa. On the right-hand side, you'll see a copy of charges that involve non-desirability and breach of rules and regs. So you'll see here they're saying an unauthorized occupant of your apartment unlawfully possessed a deadly weapon with intent to cause the death of a person, did cause the death of a person. Oh, that's a bit intense. On another date, so-and-so was arrested for criminal possession of a controlled substance. So this is non-desirability, and you'll see that it's not actually behavior of the tenant. So maybe the tenant would be able to show that this didn't happen. They don't know the person that's alleged to have been the guest or the unauthorized occupant, that this person was not under their control or someone that they know of. They could get rid of it that way. Or maybe they might have to exclude an individual as a way to resolve that. And then breach of lease, which is that you had an unauthorized occupant. So you'll probably remember that you are supposed to notify NYCHA of anyone that lives in your apartment, and you need to obtain permission for them to reside there. And if you don't, they can be considered an unauthorized occupant. So what they've done here is they've double charged, right? They've said that this person engaged in non-desirable behavior, but in addition to that, they are an unauthorized occupant, and then they're going to bring you up for breach of lease because you have this unauthorized occupant. So that's what the charges look like. I would say that is, you know, at least they're giving you a date there, 2 dates that you can look at, and they are saying that this is what happened. But again, you might want to have defenses, you might want to raise defenses to that. And then they're saying at all times in these charges, those 2 people were residents, meaning that you have to kind of deal with that aspect of it as well. Because they can, in your lease, you agree that not only you as the tenant, but household members and guests will abide by the following rules. And so what they're saying is that is a cause for them to try and terminate you because you didn't do that. So adjournments, I would say that, well, Ayana and Jessica would know this more, but now that we have right to counsel, once you have that initial RTC conference, the legal services provider is given an opportunity to meet not only on that day, but after that with the people that they have met on that intake day to decide whether or not they are going to take that case for full representation or advice. If they are going to take it for full representation, you need to submit a notice of appearance within 45 days, right, Ayana and Jess? So within 45 days, you need to put together a notice of appearance and send it to the Office of Impartial Hearings and the NYCHA attorney. I'd say that in most instances, it's pretty easy to get an adjournment first couple of times while you look into what the case is about. While you do your, you know, digging around, maybe you want to get a copy of the file that's going to need to be adjourned and things like that. And it depends again on what the kind of underlying behavior is. If NYCHA is saying that this is an urgent threat to the safety of individuals, maybe they'll be more resistant to giving adjournments. Individual attorneys are more willing than others to give adjournments. Sometimes they might say, you have to request that in front of the hearing officer. I'm not going to agree to it, but you go forward and make a request. I won't oppose that request, but I need you to make it on the record. Or they might say, I'm going to really actively oppose this request for an adjournment. You've had made way too many adjournments, things like that. There is really good language in your 5-page document of the termination of tenancy procedures that says the hearing officer shall be liberal in granting reasonable adjournments requested by the tenant or their rep for good cause shown. Take that, wave it around anytime you are before a hearing officer looking for an adjournment. Maybe the person that you are representing is chronically ill and was not able to make it. Maybe you are working really actively to try and get a public assistance printout, and there's delays in getting those. Maybe you're waiting for a fair hearing on public assistance, and that's going to make a big difference to whether or not you can get up to date with rent in a CRD case. And if you can show that you've got all of these things happening, I think that it's fair to say that a hearing officer is being directed here to think about that in a kind of expansive way and give you adjournments if you can show good cause for them. I don't think it's enough to say, hey, I put down the file on this 2 months ago and I haven't looked at it. I quickly picked it up last night and I realized I haven't done anything. I think that might be a bit of a stretch, but it is definitely in these procedures that this is to give people an opportunity to give them time to adequately defend themselves against potentially losing their apartments. So really, really lean on that. And again, think through what good cause looks like and what is a reasonable adjournment. If the NYCHA attorney is saying that you have to go on the record for an adjournment, then you should ask the NYCHA attorney to go on the record for an adjournment. It's much easier for them to suggest that we have to do that, but it's our job as well to defend our clients and make sure that they are making those same applications. So yes, I talked about a notice of appearance. If you are going to appear, then put in that notice of appearance, which will let them know that they have to contact you and give you any notices on behalf of and in addition to the tenant. It also means that they really should not be talking to the tenant directly without you being present. Examine the tenancy file. We talked a little bit about what that means. Every household has a tenancy file. It might be the full file, or it could be what they call a dummy file, which is where they've just grabbed a certain number of documents that they think probably are the cases, the files that they're going to rely on as their prima facie case to say, here's the 185, here's the 187, here's a couple of interview notes that say we did that. Here's some interview notes that say the tenant admitted the following actions. Here's a copy of the rent ledger. Here's the lease. That's all that you need to see. And we're going to say, no, actually, there's some more important things here, which is, the following. My client has, as you can see, made multiple requests for the following stuff and nothing ever happened. Or, my client has been complaining to the property manager about this neighbor for 10 years, and now you're coming to me saying that I'm the problem, like things like that. So pay attention to that, learn about the history of the tenancy, find out everything that's going on in the household, not only through your client, but through that. A lot of the time, some of the things that are going on in these cases, I would say, especially when it comes to things like misrepresentation of income, are not easily dealt with. Some people might not even know that someone's been using their address for things. Some people might not know that they have to tell their parent that they have income that they have to report. There are things that people are understandably not forthcoming with. Maybe they're ashamed of it. We've all been there. We've all been to the doctor and told them a story that might not be true. We are just the same, right? Like, we can't just expect people to share information that's personal to them. So spend time with someone. You might need to go to their apartment, I'd say, especially if it's allegations of bad housekeeping, hoarding, pets, anything like that. I think you should go and do a home visit. If they're saying it's actually my neighbor that's a problem, go there, find out, speak to some other neighbors, see if that's really what's going on, and start preparing as if you're going towards a hearing. Do you need to get records from doctors? Do you need a HIPAA release sign so you can get that? Is there a witness? Like, is there someone on that day who was there when they're alleging that your client swore at the property manager? Can they say, yeah, they did that, but the reason they did that is because I saw them trying to get something and they were being ignored? Anything that can help your client defend these charges. With settlement, I think that if you do take the case and you are starting to think through what your defense might look like, I think you should, if you can, reach out to the NYCHA rep or the attorney and say, are you willing to settle on this? What would settlement look like? And if they say absolutely not at all, I've been there is nothing here before me, because the NYCHA attorney, they really do look at the property manager as being their client. So they might say, my client, meaning the property manager, is telling me no, this is a case that they are not willing to budge on. We're going to go forward with a hearing. Sometimes the NYCHA attorney really doesn't know much more about the case than the little bits of information they've been given to put together enough facts to write that specification of charges. And if you can say to them, actually, that's not really what happened, maybe you might want to share that at an initial juncture so that the attorney can say, oh, I just didn't even know that. And then they can talk to their client, and then they can advise their client, this might not be a case that you really want to go forward with. So I think it's fair to say, to ask what that might look like. You should know that NYCHA uses a form stipulation of settlement, and so they usually don't let you mark it up, unlike in housing court, where it's kind of like a negotiation what's going to go into that stip. This is them saying, take it or leave it. This is the language we have, and if you want to settle, go for it. It usually involves a probationary period. I would say that oftentimes they try and seek a 2-year probation. You might be able to get it reduced to a smaller period than that. It's also what's known as a general probationary period. So what it will say is, for 2 years or for 1 year, if this household violates any other rules, so not just misrepresentation of income, but if they get a pet that they don't register, we can bring them up now for a violation of probation, along with charging them with that underlying behavior. It's not specific probation to the act that forms the basis for the settlement. So, for example, in housing court, in these kind of cases, we would typically, if we are going to settle one, we would say, only in the event that this person brings back another 10 dogs, can they be brought back to court for violation of probation. It wouldn't be if the client does anything wrong. So theirs is a general probation. The advantage of settlement is, right now, you will get certainty of the outcome, right? You're not rolling the dice on what the hearing officer might end up finding. but it might not be certainty over the course of the probation, right? Like you don't know whether in those 2 years something is going to happen, but at least for now, you can resolve the case and get yourself out of that immediate threat of eviction. So there is a right sizing requirement. By right sizing, what I mean is if your client is living in an extremely occupied, under-occupied apartment, so say they're an individual living in a 3-bedroom apartment by themselves, they might be asked as one of the paragraphs in the stipulation of settlement might say, by signing this, you are agreeing to be downsized to a smaller apartment for your household size. There's also language where if you are excluding an individual from your household under their permanent exclusion, they will say, if the exclusion of this individual leads to you being under-occupied, then you agree to downsize. So those are 2 of the ways in which they have managed to make right sizing mandatory, not voluntary. And in NYCHA's TSAP, which is what governs transfers, right sizing pursuant to a settlement of a termination case is one of the highest priorities for transfer. So this is how they're getting more and more people to right size. This is a copy of the form stipulation of settlement. You'll see here it says this is a violation actually of probation. They're saying we're alleging that you violated, is that right? Is this a violation of probation, Jess? I think it is, right?
No, that's just the next
sorry,
page
you
of it.
violated the following things on the following. So you did all 3. And you're going to agree to a 1-year probationary period. All household members shall agree to do this. And if none of you do that, you could be subject to violation and brought back up on violation charges again. And you have waived your right to have a hearing. I agree to this, and you'll see here it's either GAL or a rep or both. If you are going to go ahead with a hearing, we talked about the procedures, make yourself very familiar with them, print up the procedures, feel very free to make sure that you are questioning the property manager or whoever the housing assistant or witness is for the housing authority who is going to come and say, I did the following things in bringing the case, question them on it. Or if they don't even mention the fact that they brought in the client or the tenant to see if there was a way to resolve it, you might want to say to them, like, your job is as a property manager, correct? Like, you're aware of NYCHA's policies and procedures, correct? Did you do the following thing? No. And then you'll say, like, I just want the record to reflect that they said no, they didn't comply with this procedural obligation. If it's a non-desirability case and the housing authority is relying on a police officer to give some testimony, you should make sure that the officer is not in the room when there are other people testifying, or that they are not in the room at the start of the hearing listening to the testimony. They should come in solely for the purpose of testifying and then leave. If the criminal records that they are relying on have actually been sealed, the courts have said that they cannot rely on those sealed records. So you should find that out if you have any case on which they are relying on a conviction or a criminal charge. You should see whether or not it's been sealed. If you have tried to get information and you haven't been able to get it, or you need more time to get it, raise that as well. If you have got a huge delay in getting certain doctor records or any other records, say it, give evidence, like put in like evidence that you've requested it and that you are waiting for that information, because then if they say, well, I'm not waiting for that, you might be able to make the claim that that was arbitrary and capricious because they should have given you time to keep the record open for that purpose. I do think it's a really good opportunity at the end of the hearing to request time to put in anything that you don't have. So for example, if you are waiting for those records, say, can you keep the record open for another 6 weeks for me to get them? Also, if you might want to wrap up stuff in a memo that you can put before the hearing officer that kind of wraps everything up about what evidence you put in and why you think that your tenant, your client shouldn't be terminated, that's a great opportunity to do that. Sometimes we see, very recently we saw a case where the hearing officer kept the record open for an opportunity for the tenant to pay use and occupancy that was owing, and they kept the record open, but then the housing authority moved to close the record because they said that the individual had not paid the UNO, and so the decision was issued with the UNO owing, and therefore it was a negative decision for the individual. Meanwhile, the rent had been paid. So like just any opportunity you can have to keep that open for you to put in stuff, you should do that. So if you do the hearing officer will then write out their decision. Some will write lengthy decisions, some will issue very short decisions. In the decisions, you might see that the hearing officer will say, as it relates to charge 1, non-desirability for the following reasons. NYCHA didn't prove the charges. They failed to put forward evidence that makes me even get to the point of deciding on that, so we're going to dismiss those charges. And then they will round up what their findings are and say, yes, I do believe that they've proved that this activity happened, that it does constitute a threat to the neighbors and or NYCHA's employees, that I don't think that permanent exclusion is going to resolve the issue here. I don't think that the tenant can be relied on to actually stop this person from coming to their home to visit or even stay. So permanent exclusion isn't going to be satisfactory here. I am going to have to terminate the tenancy. Or I have found that this behavior happened, but I think that permanent exclusion will resolve the issue. So I'm going to say that you are eligible to remain, but you have to permanently exclude the following individual. If they are going to give probation, Escalera says they are not permitted to give probation for more than 1 year. So sometimes when you've got a case, the housing authority might be saying to you, we're going to offer you 2 years probation. And you might say, my case is pretty strong. I'm going to go to a hearing because I do think that the hearing officer will find that, yes, maybe the charges are proven, but they're going to give me probation and they cannot give me more than 1 year. So I'm going to go for it and see if I can get to the 1 year, because 2 year really could be a stretch for my client. And I'm concerned what a 2 year probation could mean for that household. So you're going to work out what you think the risks are of going to a hearing. Maybe you have no choice but to go to a hearing because they're not even offering a settlement. But those dispositions are spelled out in Escalera, and that is all that they can decide is those outcomes. I mentioned here the statute of limitations. If you do see someone that comes into your office with a decision from a hearing officer, you want to go straight to the back of that piece of paper and see when the decision was issued. Conservatively, I would base the statute of limitations off of that, and it is 4 months from the date of that decision, not 120 days, but 4 months. There is another thing that gets sent after that decision, which is, I think, the housing authority kind of adopting that decision, where they more officially say, like, this is now the decision of the authority. But just I panic about the statute of limitations because I never want someone to miss that opportunity to challenge if that's what they want to do. And so go straight to that to see what the date is. If it turns out the person has already gone past that 4 months, then you're obviously going to want to talk to them about what that now means for them. If they're within that 4 month statute of limitations, you want to advise them, you still have an opportunity to challenge this via an Article 78. And then we can talk about that, and I'm happy to answer any questions or at any time answer questions on that. We have a client right now who had a decision, and his statute of limitations was actually for today, May 28th. Luckily, we resolved the issue with NYCHA, but he was very, very conscious of this May 28th date, and so were we. And so I think it's really just very important that you immediately go to that, or if you're speaking to someone by phone and they say, I've got this decision, ask them, go to the back and just tell me when this decision was issued. These are just some of the pages from NYCHA's website that I wanted to bring to your attention around some of the things that I've mentioned on this call. Permanent exclusion, they have a whole section on their website about permanent exclusion. What is it? They have copies of the forms about if you want to lift permanent exclusion. So say you meet a client or a tenant who says, I had to exclude my son or daughter or spouse or whatever, 5, 6, 7 years ago, 10 years ago. And I really, really want them it to be lifted. So for example, I have a client right now whose son was excluded. He ended up getting shot and paralyzed, and he's now in a wheelchair, and she is his sole caregiver, and he needs to reside with her because she is taking care of him. And we are seeking to lift that permanent exclusion before the passage of time. because of that. So you can seek to lift it for either behavior and changes in behavior, or automatically, or seek to lift it for passage of time. That is all spelled out in these pages, and you can also always reach out to us if you have questions. Again, it used to be permanent, so this is kind of exciting. And while a horrible thing to have to use, because it really does mean that someone cannot visit or stay with the person in the household anymore, it is a way to save the housing for the rest of the people that live in that apartment. This is the ACOP, which I mentioned earlier, which is basically all of the policies and procedures are available on their website here under this document, the ACOP. You will want to go to the other, like, management manual and other things just to top off the fuller policies and procedures, but this is where you'll at least see an outline and their policies governing many of the things we spoke about. So rent, occupancy standards, transfers. I wanted to talk about reasonable accommodations. I'm hurrying up because I'm looking at the time and I know we're running out of time. One of the ways in which you might want to resolve a termination of tenancy case is through making a reasonable accommodation request. So maybe some of the behavior that was going on was a result of someone's disability, and you need to make a reasonable accommodation request. Were they struggling to get in the door to the building because it didn't have appropriate ramps for them to get in? That led to behavior that then they are bringing you up on a charge for. Are the elevators always broken, which means that the person is stuck in the lobby, unable to get up to the apartment and take care of themselves? Is that the basis for some of the behavior alleged? Do they need an extra bedroom? Things like that. So that's their policy. That will give you information about where to file the reasonable accommodation request. You might see someone that cannot physically or is unable to go in person to a termination of tenancy hearing. I would say that you might want to also lay out the ground rules with the NYCHA, either a housing assistant or attorney with whom you are working on these cases, to say, like, are we doing this fully remote? Are we doing this in person? I think it's important to establish what you are looking for. If you do need to accommodate someone to appear remotely, try and get on board with both of you understanding when you're going to invoke that. But this is where there's information about how to do that. And if someone is unrepresented, at least they can see what their remote hearing options are. This is the FOIL address. So if you do have a need to get access to any files or policies that are not being offered to you, you can submit your request. It doesn't have to be anything kind of official or fancy. You can just send an email that says, pursuant to the FOIL law, I want to get access to the following documents. And is that me, Jess? That's me out of time. And
Yeah, that was everything.
That was it. I hope that was helpful. We are always here to answer any questions that people may have about termination of tenancy cases. I'm hoping that you're not going to see so many people who are saying that they were unable to get an attorney or representation because they didn't even know that they had the right to that. But if you do, then you should let us know and or tell them to go to 803 to get the list. Or is there a list available, Jess? Is there a list available of, like, the legal services providers that they attach to that RTC notice?
Let me take a look.
But hopefully people are getting the RTC notices and showing up to that first appointment. But if they don't, try and urge them to go and get in touch with a legal services provider to see if they can get representation. And if they have a default, urge them to go and vacate the default or challenge the denial of their application to vacate the default. And if they have a decision and they're showing you a decision that terminates them, see what the date is and urge them to go and appeal it before the statute of limitations runs out. You can always file an Article 78 and then amend it. The most important thing is to get it in before you run over the statute of limitations, because then you're really out of luck with an appeal. So those are really, for me, the things that you have to remember when you see anything to do with termination of tenancy.
And that initial right to counsel notice doesn't have the list of providers.
Okay.
So I think that comes.
But we are definitely seeing people who are not showing up. And so it's very possible that people are showing up then when they get the second notice, and they should know that they do have options to get an attorney.
And I don't know if you had already mentioned, and maybe I missed it, but you said that there was a training you used for Article 78. I know we get
Well,
just
I don't know if you do one, but there's definitely some out there. I know that PLI has one that some of our colleagues do from legal services providers. That might be tricky for some people to get access to, but there is kind of good stuff online, and the state Supreme Courts do have a good pro se office around filing of Article 78, but maybe we should think about doing a I just offered NYCHA my look at that. I can't
yes.
myself. But it's not that tricky. You can go to court and they will show you, like they do have a booklet, I think a basic booklet about Article 78, but there is stuff online. If you just Google it for New York Article 78, there is pretty good resources available.
Okay, great. And I will follow up on the training about that for you. But yeah, I think we're out of time, but thank you so much to Lucy, Ayana, Jessica, for this training. It was super helpful. I know we've been getting a lot of questions and clarifications, and now we all know how to overturn the decision. So yeah, thank you so much, and I hope everyone found the training helpful as much as I did. And yeah, have a great afternoon, everyone.
Thank you
And
so much. And
remember,
please feel free to reach out to us if you have any questions. We have did you put it in the chat, Ayana, our number? You can also email our email address, which is publichousingunit@legal-aid.org. But we're always happy to answer questions if you come across someone that is in this situation. And thanks, NYCHA.
first, and then just to let everybody know, we do have additional trainings we have added for the rest of the spring training series. So we have a new one on rent stabilization, so feel free to check it out. I just posted the link. But otherwise, if we have nothing else, have a good evening, everyone. Stay